Yes, Mr. Matthews.
My Lord, may I start with just a few housekeeping points? Transcriber breaks. It's been indicated to us that the transcriber has kind of confirmed that if it's more convenient to the court, they will forego their breaks. So we're in your Lordship's hands on that.
All right.
Secondly, we've provided the document requested in respect of the factual position on the two signatures and the manuscript entries, and we've obviously dealt with that in an effort to be helpful in some detail, but the short point is, first of all, the two signatures point, which appears to be obviously wrong, and yet vital for the reasons indicated yesterday. And I don't propose to go back over all of this to the judge's assessment of credibility as part of the general assessment of credibility, and the second point, obviously, the supposed 2015 focus on the 26th of September 2008 date, when it's obvious from the contemporary correspondence that that was the date being mooted and then rejected in 2009, and not a 2015 development. And the third point of housekeeping is that your Lordship asked, Lord Justice Males asked for the references to where Mr Vik had dealt in his evidence with his understanding of the meaning of the questions and answers at the Part 71 cross-examination hearing in relation to the assets of Beatrice and the Trust, and the answer to that is it was dealt with in Mr Vik's first affidavit at paragraphs 18 to 26 in our supplementary bundle 2, tab 13, pages 444 to 446, and in the transcript of the hearing before Mrs Justice Moulder, day 8, page 67, line 12, to page 80, line 20, at which is in our bundles, the core supplement at tab 6, pages 54 to 56, 54 to 57, and in particular at page 56.
Thank you very much.
The fourth point of housekeeping, and the final one that I have, is the letter of the 17th of December 2021, which your Lordship asked for. That has been sent to your Lordships electronically and added to the e-bundle at tab 40 of the supplement bundle. I have hard copies if the tribunal, if your Lordships and Ladyship would like a copy.
I don't need one,
No,
but I
don't.
have received
Thank
that.
you.
Thank you very much.
I'm grateful, Lord. So that is all I propose to say by way of introductory housekeeping.
Yes?
We were dealing with the evidence to support, to the learned judge's foundational points for her conclusion about deliberate falsehood in relation to the Beatrice and Trust assets, and I was coming on next to deal with the position in relation to the evidence to support the plausible theory that the trustees supervised Beatrice assets with the assistance of a fund manager. We've dealt with that at the skeleton argument, paragraph 108 to 114. I have one small typographical error, which I'd be grateful if I could correct on the skeleton argument, which is...
What paragraph did you say?
The subject generally is dealt with at 108 to 114,
Yep.
and the specific paragraph is at paragraph 110, and it's over the page at page 65 of the bundle, footnote 18, where we cross-refer to the trial judgment, paragraphs 1435, Roman 1 to Roman 2, and that should have been Roman 3 rather than Roman 2. So Roman 1 to Roman 3. Those are the positions in relation to the transfers. And what we simply say in relation to that is that the judge failed to take into account that there was no evidence that the assets of the trust were anything other than the shares in Beatrice, and that the assets of Beatrice were in any sense complex rather than cash or cash equivalent. And there was evidence that the trustees relied on the management of the assets by HSBC. We deal with that in our skeleton at paragraph 112, subparagraph 2, on page 65 of the bundle. And in that context, if I can briefly take the court to core supplement bundle tab 36, which is the deposition evidence of Mrs. Vik, which was before the judge on the Mr. Justice Moulder. And her evidence in the Connecticut proceedings, if we turn to page 276 of the bundle, if I can just first of all pick up one point of correction or clarification from what I said yesterday. Your Lordship and Ladyship will see that there is, beginning at paragraph 9, line 9 on page 276. So you and your daughter were in charge of the trust, and I think I saw something saying the trust was like the sole director of Beatrice. So yesterday I think I told the court that it was the trustees that were the directors of Beatrice. It's in fact the trust that was the sole director of Beatrice. Not sure that makes any material difference, but there we are. And in this context also, that is the basis upon which Mrs. Justice Moulder proceeded, which the court can see from the judgment at paragraph 173, where Her Ladyship said, insofar as it was submitted that the trustees did not need to have any relevant experience or qualifications, I also take into account the fact that the trust was the director of Beatrice.
Well, unless Delaware law is different from English law, a trust is not a legal entity. It is just a name of trustees holding assets. So I'm not sure that a trust could be a director in a technical sense, but it's obvious what's meant. Trustees in their capacity as trustees and directors.
Exactly. From a practical point of view, I'm not sure that it makes any difference at all. But I did think that I should, having told you yesterday the trustees, I should correct that, having spotted that. But moving on page 276, we come on to the point that, specific that I was dealing with. And the judge asked, well, I was just wondering what happened during the time it was within the trust to the money. Or you were saying Beatrice makes investments and stuff. What did they do for that period? Answer, well, HSBC managed Beatrice over the page, so we just left it to HSBC to continuing managing it. There was a loan facility between Sebastian, SHI and Beatrice, which is a separate point. There were investments that they'd already been managing, so we just said continuing managing. So that was the status quo. That was the status quo. You were going to leave it in place. Correct. So the short point, we say, is that, that there was evidence in support of the suggestion that the trustees themselves didn't need to be involved in active management because HSBC was acting in that role. Contrary to the position, therefore, as stated in the defendant's skeleton at the Deutsche Bank skeleton, paragraph 38A, Roman 2, where they say there was no evidence that the trust, it is said there that the trustees looked to Mr. Vik to manage the trust. We say that there was no direct evidence of that. That is the inference that Deutsche Bank asked the court, we say, wrongly to draw, and that the court did wrongly draw, which we see from paragraph 156 of the judgment. We say, contrarily, paragraph 113 of our skeleton argument, that there was indeed evidence to, in relation therefore to HSBC's role. We've seen that, and it's we make the point in paragraph 113 that the Deutsche Bank invited the judge to dismiss the evidence in relation to HSB on the basis that Mr Vik adduced no documentary evidence of HSBC or anyone else providing such fund management services to Beatrice. And we make the point that under the terms of the trust indenture, Mr Vik would have had no involvement in arranging or supervising it, and there's no reason to suppose that he would receive or be entitled to a call for Beatrice's documents, as he explained in cross-examination with the reference given there. And there was no evidence to show that Mr Vik would indeed have had power to call for Beatrice's documents in circumstances where Mr Vik had no role under the trust deed in relation to the management of the trust's assets. And in this context, it's worth bearing in mind the fact that Mrs Vik, who was the trustee, clearly took an independent position in relation to the documents and other matters relating to the trust, and we see that best in the judgment at paragraph 160, well, first at 118, subparagraph 10, at paragraph 118 of the judgment on page 209, Mrs Justice Moulder begins a recital of various items of evidence which she notes, and at subparagraph 10, at the bottom of page 210 of the bundle, Mrs Justice Moulder says, the trust deed was only disclosed in October 2015. Previously, Mrs Vik, who was at the relevant time a trustee of the trust, was not prepared to provide a copy to Ms Asgharian, a lawyer acting for Mr Vik. When asked in the course of her deposition for the Connecticut proceedings why she had refused, Mrs Vik replied, because I didn't want to. Why? Protect my family from? I didn't want to. I just didn't think it was appropriate. To protect your family from what? It's my children. I protect my children. And so there's no doubt.
That doesn't show it's an independent view, independent of Mr Vik.
Sorry, my lord.
I said that doesn't show that her view is independent of Mr Vik.
No, that she takes a stance independent of Mr Vik in this sense that Mr Vik's lawyer asks for the document in question, and Mrs Vik, in order to protect the interests of her children, declines to provide it. And in that sense is not doing as requested by Mr Vik's lawyer, his agent, but on the contrary is doing what she thinks is appropriate to protect the interests of her children. And the learned judge returned to it at paragraphs 162 and 163, where she says, as noted above, that's the passage I've just taken you to, Mrs Vik refused to disclose the trust deed to Mr Vik's lawyer on the basis she wanted to protect her family, submitted for Mr Vik in oral closings that his wife's refusal to hand over a copy of the trust deed demonstrated a determined woman who was taking an independent stance on behalf of the trust, redolent of Mrs Vik acting as the trustee of a legitimate trust for the protection of her children's inheritance. And the learned judge concluded, whilst I infer that Mrs Vik was doubtless trying to protect her children's inheritance by her refusal to hand over a copy of the document, and as a trustee she had power to do so, her refusal to disclose a copy of the trust deed does not provide evidence that she was either competent to manage the assets of the trust or actually involved in the management of the trust, which is, of course, the different point. So we say that there was evidence before the judge in relation to the role of HSBC to support the position that even though, well, essentially, that the way in which these cash or cash equivalent assets was being managed was by way of continuation of what was happening before under the management of HSBC, and therefore it is not possible for the judge to conclude, beyond a reasonable doubt, that that was not a correct analysis of what was continuing to happen afterwards. And if that's right, well, you don't need an independent trustee who's got power or capacity, if it's being suggested, sorry, not capacity, but the ability to manage complicated investments in those circumstances. And therefore, we respectfully suggest that that plank of the judge's analysis also goes. The next point that she addressed was that Mr Vik suggested that Mr Vik had a need to keep a close eye on the assets because of the Beatrice credit line with SHI. We deal with that in our skeleton argument at paragraphs 115 to 120. And we say again that the judgment is in error in relation to this point. The fundamental point in relation to this is that $750 million, or in fact Norwegian kroner equivalent, had been transferred into Beatrice in 2008. The evidence showed that the flow of funds in relation to the credit line between Beatrice and the trust, between Beatrice and SHI, only called on funds to a maximum at any point of $80 million and to a net draw on the Beatrice funds of $25 million. And in those circumstances, we would respectfully submit it's clear that there is no reason to infer from the needs for that sort of level of funds that Mr Vik would have had to have kept a close eye on the investments of Beatrice when he's, the intention had been cash and cash equivalent assets of that sort of level being transferred. The percentage element of that which was taken up in the Beatrice SHI credit line was tiny by comparison. And the idea that there would have been, these were not high-risk investments, the idea that one had to keep a close eye on the Beatrice investments in order to be sure that the credit line would be available at that sort of level, it is, with respect, we say, clearly not the case. It's clearly
did I just hear you say these were not high-risk investments?
Cash and cash equivalents.
Oh, right, okay.
There are others which we are dealing with, partnership interests, biomedical investments and so on, but that's nothing to do with this sort of thing. The investments that were involved in the evidence in relation to the investments that went into Beatrice was that they were cash and cash equivalents and therefore not high risk. I mean, obviously, there's some risk associated with anything. The bank may go bust, but they're not high risk in the sense that compared with the Devon Park or the partnership interests, which were obviously a completely different sort of investment and not being handled through or by Beatrice. And so clearly we say, given that massive disparity between the sort of level of drawings through the credit line and the amount of relatively risk or low risk investments that had gone into Beatrice, that wouldn't have triggered any need to have a close eye on Beatrice's assets. And on any view, there was simply no basis for concluding that Mr Vik must have been keeping a close eye on the assets in order for the credit line to operate, and that is enough for my purposes. The fifth and final point relied upon was that related to Mr Vik's having been advised to keep his distance from the trust. We deal with this in our skeleton argument at paragraphs 121 to 124. We respectfully submit that there was no proper basis for refuting Mr Vik's sworn testimony that he was advised to and did keep his distance from the trust. On the contrary, we say that was entirely plausible and consistent with the evidence and the actions taken. And we explain at paragraph 123 in the 6 sub-paragraphs there why we say the judge's reasoning for rejecting Mr Vik's evidence is untenable. And of course, the starting point on this, as in all the others, was the court's general assessment of his credibility. But in the interests of time, I'm not going to go through the individual items in paragraph 123, but take them as read. The one additional point that I would make in relation to 123 point, subparagraph 3 is the judge refers at 170 subparagraph 2 of the judgment to the point that it was not raised by Mr Vik at the Part 71 transcript of his evidence that he'd been acting on legal advice, and the short point there is that this was not a point that Deutsche Bank had raised. They raised it in their closing at paragraph 62D on the basis that it was new evidence, but he was not asked at the hearing before Mrs Justice Moulder as to why he had not raised it before at the Part 71. So that is the position in relation to the advice to keep his distance from the trust. There's one separate point, which is the funds, the conclusion of the court that there was a deliberate falsehood in relation to Mr Vik's knowledge of the funds of SHI held by Beatrice in 2015. We deal with that in our skeleton argument at paragraph 126. Just to unpackage it a little, in the judgment at paragraph 204, subparagraph 2, or Roman 2, on page 232, one of the findings that the judge made as to deliberate falsehood in the Part 71 evidence was she held that at the date of the cross-examination hearing, that's the Part 71, Mr Vik did know, subparagraph 2, what funds of SHI were held by Beatrice at the date of the cross-examination hearing. So the finding, and one of the elements of the deliberate false testimony, is said to be that Mr Vik did know what funds of SHI were held by Beatrice in 2015. And that is also a finding that carried through to the schedule of findings of contempt in the Schedule A to the order, which we're appealing from at Core Bundle, tab 8, page 175, paragraph A, Roman 1, 1b, that there is no independent reasoning in the judgment as to how she reached that conclusion. It has to be set together with the fact that the judge did not make any findings and said she did not need to make any findings as to the circumstances in which the assets had been transferred from SHI in 2008. And we see that from the judgment at paragraph 134, where she says, the issue is not whether the findings of Mr Justice Cook are binding on this court as amounting to a form of issue estoppel, or whether the Connecticut court was right when it found that Mr Vik did not transfer the assets out of SHI to Beatrice in order to prevent the bank from getting those assets. The significance lies in that Mr Vik knows that the bank's case is that the relevant assets were transferred out of SHI to Beatrice with a view to depleting SHI's assets and to make it more difficult for the bank to seek recovery. And then again at paragraph 164, dealing with the argument that we had advanced that a key plank of the bank's case was that the trust was a sham and a device to try to hide from the bank what the bank alleges were SHI's assets. The learned judge refers to the fact that Deutsche Bank's case was that no such finding was necessary. The issue of Mr. Vik's knowledge of the assets of the trust is not dependent, and Beatrice, is not dependent on finding that the trust was a device to shield assets from the bank. In my view, contrary to the submissions for Mr. Vik, the court is entitled to conclude that Mr. Vik continued to keep a close check on the assets. It is not, therefore, necessary for me to consider whether the findings of Mr. Justice Cook give rise to an issue estoppel, or to consider the findings of the Connecticut judgment as to Mr. Vik's intent when he made the transfers from SHI to Beatrice in October 2008. So the learned judge didn't explain why Mr. Vik would have known in 2015 whether the assets that he had transferred in 2008 from SHI were SHI's assets in 2015, and the judge specifically disavowed any analysis of the circumstances in which those assets had been transferred out, which might have formed the basis for an analysis as to whether they were or were not SHI's assets. And so there is, in fact, no analysis at all as to whether, and if so, on what basis, any of the funds in Beatrice in 2015 were or were not funds of SHI. But in any event, there is also no analysis as to how Mr. Vik might be expected to have known whether they were or were not SHI's assets at that time. So that is the final point dealing with that, and that is all I propose to say in relation to Beatrice and the trust. I'm then going to move on to Devon Park and Universal.
Can I, just before you leave that, ask you where we find the question in relation to the point you've just been addressing us on? Do you know what assets of Beatrice, what assets of SHI are held for Beatrice?
I will look for that. I thought I'll come back. It's is your lordship asking in relation to the Part 71?
Yes.
Yes.
What is the answer which is said to have been deliberately false?
Yes.
Yes.
So I'll come back to that if I may, my lord. But in the turning to the Devon Park and Universal, we turn to that in our skeleton at paragraph 127, and the issue obviously arising in relation to this is that as to SHI's interest in the Devon Park investment and whether it was sold to VBI pursuant to a 2012 sale agreement and thereafter transferred to Universal in 2014 on the instructions of VBI. Secondly, whether Mr. Vik had any connection with Universal. And obviously when I refer to Mr. Vik, I'm referring to my client rather than to his father, which was a separate area of analysis in relation to Universal. And thirdly, whether Mr. Vik had nothing to do with SHI by the time of the Part 71 cross-examination hearing, which were the 3 points found against Mr. Vik in relation to this. Turning first to the 2012 sale agreement, it is, has been alleged by Deutsche Bank and found by the judge that the sale agreement was not bona fides. The judge relied on 3 matters in relation to that, which we set out in the skeleton at paragraph 130. Firstly, an inference that she said she was entitled to draw from the existence or absence of contemporary documentation in relation to the 2012 sale agreement. Secondly, a suggestion of belated disclosure of the 2012 sale agreement. And thirdly, a complaint of even later disclosure of a detailed schedule of assets said to have been transferred under the 2012 sale agreement. In our submission, none of these is a valid basis for drawing any inference individually or cumulatively. It's never been explained what case Mr Vik is actually supposed to meet on this bona fides claim, even at such a basic level as whether it is suggested that no such document came into existence in 2012 but was of later invention, whether it's suggested that the document did come into existence in 2012 but was not intended to have the effect stated in it, or whether there's some other alleged lack of bona fides which has never been elucidated either. Turning then to the first of the 3 points, the contemporary documents, we deal with this in our skeleton argument at 130 subparagraph 1 and paragraphs 131 to 136. There are only 2 documents identified as said to be contrary to Mr Vik's case. Firstly, the September 15th, 2014 written instruction from SHI and Devon Park to JP Morgan, and secondly, the AAA agreement of the 19th of August 2014. In our submission, neither document achieves the result of undermining the 2012 sale agreement, and indeed there is evidence to the contrary supportive of the validity of the 2012 sale agreement, which was overlooked. If I take first the written instruction of 15th September 2014, we deal with that in our skeleton argument at paragraph 132. The document in question relates to funds held in an escrow account to cover future capital contributions and proceeds on the basis that SHI had an interest in Devon Park and in the funds. This is in September 2014. Well, of course, in September 2014, vis-à-vis Devon Park and JP Morgan, SHI would have had, because although it had sold the asset to VBI under the 2012 sale agreement, it had not transferred the interest to VBI. The approval of Devon Park would have been required for that and was achieved at a later point. Accordingly, SHI, on any view, in September 2014, retained at least the legal interest. Devon Park had not recognised any transfer of such interest away from SHI, and neither Mr Vik nor SHI had ever suggested otherwise. Clearly, the beneficial interest had been transferred to VBI pursuant to the 2012 sale agreement. Furthermore, your lordships and my lady will be aware of the fact that there's a suggestion that because of the Norwegian law basis, I'll come back to this, but because of the Norwegian law basis of the 2012 sale agreement, and it is said that Norwegian law does not recognise the concept of a trust, but there is, was evidence to suggest that the effect between the parties to an agreement to transfer the interest nevertheless has effect, but only as between the parties to the agreement. It doesn't have any impact by way of impacting the legal or beneficial interest.
Well, was there any Norwegian law evidence?
There was no Norwegian law evidence. You're absolutely right, my lady. What
how
happened?
do we know what the effect is in Norwegian law if there was no Norwegian law evidence?
We don't, in this sense, if the case is that there must be some effect in Norwegian law different from English law in relation to the effect of this, then obviously the burden is on the person alleging that to prove and establish the different position under Norwegian law. The only thing that was advanced in relation to that was the passage from the trial judgment in relation to the Mr Justice Cook's comment in relation to that. And also, as I've indicated, it's one of the aspects of the additional evidence, which I'll come back to in a moment in relation to that. So the only point in relation to Norwegian law, to the extent there was anything at all, was that previous decision of Mr Justice Cook.
I'm sorry to write, it's just it's not accurate. It wasn't the trial judgment, it was Mr Justice Cook's judgment on the conditions application, where he considered the sale agreement and Norwegian law evidence. He made a finding. That finding was not challenged before Mrs Justice Moulder, and it's only now that my learned friend is seeking to adduce new evidence, which actually doesn't challenge it either. So when he said there was evidence under Norwegian law that there was a different arrangement, that is not true.
Well, I was going to ask Mr Matthews about saying there was evidence, because my understanding of the submissions on the application to adduce new evidence is that below, Mr Vik relied on the presumption of similarity.
But he also didn't challenge and adduce any other evidence to say that the evidence before Mr Justice Cook was wrong. So there had been evidence. Mr Justice Cook made the finding on the sale agreement to an application that Mr Vik was party to. And
was Mr Vik a party?
It was the conditions application.
Condition of what?
And non-party costs application. Conditions to be able to appeal.
Yes, but the appeal was not by Mr Vik, it was
But
by SHI.
But the non-party costs application was against Mr Vik, and he was found to be the real party. So he served his own evidence at that application.
So did he seek to appeal the finding, the non-party cost order?
Yes, he did.
And is it in connection with that appeal that Mr Justice Cook made his decision?
Can I show you the decision? It's at tab 3 of bundle 1 of the authority. You can see it.
Maybe we should deal with that.
I think perhaps rather than interrupt Mr Matthews, we'll let you come back on this.
That's fine. I'm just saying that what you've been told is, I'm afraid, not accurate.
Yeah,
and
all right.
just to bear that in mind.
As I hoped I had clarified, our position in relation to the presence of Norwegian law evidence was that the position before Mrs Justice Moulder was reliance was placed upon the decision of Mr Justice Cook. Objection was taken to the admissibility of that in relation to the finding of Norwegian law. And the evidence from the Kluger memo is a matter for the additional evidence application. And it's not clear to us, but Mr Lena will no doubt deal with it in her submissions to explain why there's a binding decision that impacted my client rather than SHI, even if it was binding on SHI.
Right. Well, in due course, perhaps you could give us the reference to the objection to the admissibility of Mr Justice Cook's findings.
Yes.
Is there a principle that if one English judge has decided that a foreign law, there is a particular matter of foreign law in a particular way, then that can be relied on in subsequent cases between different parties?
There is a principle that if you can plead and prove a decision which has been made by a judge in relation to a point of law, yes, foreign law.
That's what I thought.
Yes.
So the fact that you're not a party to a previous decision doesn't prevent you from relying on a previous decision, as it were, as a finding of fact. It's a slightly odd principle, isn't it?
It is a very strange principle, no doubt intended to diminish the extent to which this court has to revisit and decide points of foreign law. The short point that we're making in relation to this is that the evidence, insofar as there were decision of Mr Justice Cook in relation to this, amounted to the fact that there was no trust equivalent provisions or legal principle in Norwegian law, and in the circumstances, what he didn't address was the question which I'm focusing on now, of whether, if that effect of that was not to transfer any legal or beneficial interest to VBI, it still doesn't alter the position that on that basis, the 2014 document would have been true and not inconsistent with the existence of the 2012 sale agreement, because if the 2012 sale agreement did have the effect for which Deutsche Bank is arguing, then the 2012 sale agreement would at most have transferred and would at most have created a legal right as between SHI and VBI, but would not have been effective to transfer the legal or beneficial interest. And if that is right, it doesn't undermine the existence of the 2012 sale agreement.
I understand that, but what I have, I'm afraid, completely failed to understand is what Deutsche Bank's position on Norwegian law before Mrs. Justice Moulder was, what your position on Norwegian law before Mrs. Justice Moulder was, and what her decision was.
Let me try again.
I'm so sorry.
No, it's not. I haven't made it clear, and I also misspoke at one stage, so that hasn't helped either. The position on Norwegian law before Mrs. Justice Moulder was that the Deutsche Bank relied upon the decision of Mr. Justice Cook to the effect that Norwegian law had no knowledge of a principle of trust law, and therefore, in effect, the argument of Deutsche Bank below was this is a very strange agreement. If it's agreed to be subject to Norwegian law, but it creates, by its terms, concepts of trusts, which Norwegian law doesn't recognise.
Yes, and what was your position?
Our position was there is no admissible evidence before the court in relation to Norwegian law. And what we said was that whether the 2012 sale agreement took effect as a matter of effective to transfer any interest under Norwegian law or not, didn't undermine the 2012 sale agreement. It doesn't show.
Were you positively asserting that in the absence of any admissible evidence of foreign law, the Norwegian law should be assumed to be the same as English law, and therefore it did know the concept of a trust? Or what was the position?
May I just, because I don't want, my recollection was that we were saying that there's no evidence of Norwegian law before the court, no admissible evidence, and therefore the court must proceed on the basis that Norwegian law and English law are the same. But I will check that, and so we can come back to it.
I might have thought that the judge would take judicial notice of the fact that because Norway is a civil law system and not a common law system, it's very unlikely that they'd recognise the concept of a trust.
Well, there is also that, my lady. But the point that I'm trying to make here is a short one, which is that whether the 2012 sale agreement does or does not have let me start again.
Your point is, if it did create a trust, it doesn't matter because the SHI would still be the legal owner, and therefore the right person to give the instructions. And if it didn't create a trust, it doesn't matter because SHI would still be the legal owner and beneficial owner and the right person to give instructions. That's your
precisely.
Point. But you did make a point. Having made that point, you did say, and we've got the Norwegian law evidence, which is the subject of the application to adduce further evidence. And at the moment, I don't myself quite understand how that fits into the analysis. But
Yes, all I'm saying in relation to that is, and I'll come back to the application in a moment, all I say in relation to that is that if the effect of Norwegian law is as stated in the Kluge memo, for which application is made to admit it to this court, not having been before Mrs. Justice Moulder, if the effect of Norwegian law is simply that there is a contractual right created between the two parties, but it has no effect on the legal or beneficial interest as regards third parties, then again we say that doesn't in any way impede or affect the written instruction of 15th September 2014, proceeding on the basis that the interest rested with SHI, because in law it did.
Mrs. Justice Moulder's view that the reference to a trust in a Norwegian law document indicates that there's something funny about it doesn't really depend on the Kluge memo, does it? I mean, it's either a good point or a bad point on its own terms. The fact that Norwegian law doesn't recognise the concept of trust, but nevertheless finds a way of enforcing something which purports to be a trust, which seems to be what the Kluger memo says, doesn't really impact on whether somebody drafting a Norwegian law contract would put a trust in there.
Well, I see. It's not the strongest of points, I have to accept, my lord, but the fact remains that when one's dealing with the two documents relied upon by the judge as being contrary to Mr Vik's case on the validity of the 2012 sale agreement, the first one, which is the 15th September 2014 written instruction, is not contrary to Mr Vik's case on the existence and validity of the 2012 sale agreement. On the contrary, it is entirely consistent with what had happened under the 2012 sale agreement by the time of September 2014 in relation to that. And so either way, we say the written instructions were not inconsistent with the 2012 sale agreement. And just to cover off, your court is obviously ahead of me in relation to the Kluger memo, but that is in the additional bundle 1, tab 4, and we address it at paragraphs 3 to 5 and 11 to 17. And the short point is that we say that the Kluger memo demonstrates that a Norwegian law agreement purporting to create a trust will not be ineffective or too uncertain to be enforceable between the parties to the agreement. But that it's not necessarily it's not really the bona fides point, because it goes back to the question of what is the allegation in relation to absence of bona fides. It would, in some senses, go more to the question of whether the 2012 sale agreement is enforceable and effective on its face, rather than having been entered into having been entered into on a some sort of sham basis, or having been a later creation. So it's a short point in relation to the Norwegian law. We say none of it goes very far in any event. It is a huge edifice to construct on the plank that, well, whoever drafted the 2012 sale agreement put in Norwegian law, but also put in a trust arrangement which Norwegian law doesn't recognise, to go from that to say, therefore I conclude that it must be not bona fides. I mean, the really odd thing about it is, why does that mean that the 2012 sale agreement is a later invention? If anything, one would think that if it's a later invention, one would have taken more care to make sure that the Norwegian law applicable was one that actually recognised the trust concept, or the proper law identified in the contract was one that recognised the trust basis, rather than putting forward...
Depends on how much of a hurry you are in to create the concocted document, doesn't it?
Well, it is...
People can be slapdash, Mr Matthews, and that's often how they get caught out.
Well, they do, of course. But we say that it's rather more consistent with the informality of an arrangement between father and son for the sale of assets, which is perhaps a more plausible and certainly not an explanation which it's proper and appropriate to rule out when one's looking at the standard of proof that we're concerned with here. When one bears in mind that the 2012 sale agreement was an agreement between father and son in relation to these assets, is it more likely that somehow this was concocted at a later date, and that's why, as your ladyship suggests, perhaps in a hurry, they put in Norwegian proper law and a trust, or is it more likely perhaps that they weren't too concerned with the detail of it in 2012, because it was a document, but ultimately one giving effect to an arrangement between father and son. The other point that's raised is in relation to the AAA of the 29th of August 2014. That we deal with in our skeleton argument at paragraph 133. The AAA, the assignment and assumption agreement, was the agreement by which SHI agreed to transfer the interest in Devon Park to Universal. We say at the instruction of VBI, to whom we had already transferred, whom SHI had already transferred the interest, to whom SHI had already sold the interest in 2012 under the sale agreement, but was now giving effect by way of transfer at the instruction of VBI to transfer that to Universal. It's a very short point. There was a statement in the AAA that SHI was the beneficial owner, and it said, well, that's inconsistent with the 2012 sale agreement by which it had transferred the beneficial interest to VBI. And the question then is whether it's more likely that the 2012 sale agreement was somehow not bona fide.
I mean, you say it is said that. I mean, I think you agree that they are inconsistent, don't you?
Yes, subject to the wrinkle about the Norwegian law point, but yes. Because if the Norwegian law point were right, that it's effective only to transfer, to create a legal right, but not to transfer any legal or beneficial right, then technically, actually, there wouldn't even be an inconsistency. But the short point is, yes, insofar as the AAA in clause 3C, as we set out in paragraph 133 of the skeleton, says that SHI owns all right, title and interest to the Devon Park interest. That would be inconsistent with the 2012 sale agreement having transferred the beneficial interest in it to VBI. It's an odd one, this, in the sense that effectively the question becomes, is it more likely that the 2012 sale agreement was somehow not bona fide, or was an incidental or accidental misrepresentation included in the AAA? And there is no obvious explanation as to why the misrepresentation might have been made rather than acknowledging VBI's interest. Because there's no doubt that from the point of view of SHI, it was fully entitled and indeed instructed by VBI to make full transfer of all interests to Universal. And that is what SHI was purporting to do in the assignment and assumption agreement. And so in those circumstances, we respectfully suggest that it is more likely that the 2012 sale agreement, it was in existence, had given the right to transfer the funds, the Devon Park interest, to VBI or to VBI's order, and that the assignment and assumption agreement in 2014 was giving effect to that obligation. And as I say, it comes back to the question, which remains unclear. Is it being said that the 2012 agreement had not come into existence as at the time of the assignment and assumption agreement, which is, I think it is being said that it hadn't come into existence by the 29th of August 2014. So if it's accepted that it had come into existence as at that time, then is it being said that it was of no legal effect and therefore not bona fides in that sense? But if it had come into existence even in April 2014, then the fact that there's an inconsistency between the sale agreement and the assignment and assumption agreement doesn't tell you anything about whether the sale agreement of 2012 had been created earlier than the assignment and assumption agreement in 2012 or in 2014. So again, it's difficult to see how this can be evidential proof of the fact that the 2012 sale agreement was not a bona fides or genuine agreement.
It is odd, though. I mean, I understand entirely that you can contract to sell an asset from A to B on terms that A will convey either to B or to B's order. But normally in those circumstances, when A conveys to C at B's order, you recite the fact that it's been contracted to sell to B and that B has directed that it be conveyed to C, and the payment of the consideration doesn't go to A, it goes to B because B is the... Here, there's none of that. There's no recital of a sale to VBI. There's no reference to it being at VBI's order or direction, and the payment goes to the assignor, not to somebody who's not mentioned it. On its face, it looks like a sale by a beneficial owner, and that is odd. Is it not?
The position is slightly complicated by the existence of evidence going the other way, amongst which was a document that Deutsche Bank put in redacted form at a late point in the hearing before Mrs. Justice Moulder, which is the purchase and sale framework agreement between VBI and Universal of the 9th of July 2014. So, whilst I see the force of Lordship's point, if there were no indication of the existence of some other agreement between VBI and Universal, there is that document of 9th of July 2014. That document was made available to Deutsche Bank in American proceedings to which my client was not a party, and my client has not seen it. It is some evidence of the contemporaneous evidence of the transfer from VBI to Universal.
Well, according to the judge, you resisted that document being put before her.
We didn't resist the document being put before. What we objected to was the fact that what Mr. Robinson in his witness statement sought to do was to expand upon the document and seek to argue as to why and put evidence before the court going beyond the evidence that was in Mr. Hart's affidavit, which was supposed to be the limit of the evidence before the court in relation to the contempt proceedings, as to why the court shouldn't give any credence to this agreement, this additional agreement. And so we objected to the fact that the court was being made aware of the existence of an agreement, and it resulted in the Deutsche Bank having to make an amendment to their skeleton argument. But at the same time, Deutsche Bank was seeking to produce new evidence to try to undermine or defeat the basis on which they were having to make that correction. And so...
But I mean, the fact is that that document was not before the judge, and neither party therefore put it in evidence, and she said, not surprisingly, 283, she could give it little or no weight.
Well,
I mean, now you are trying to tell us about it and rely on it.
The fact of its existence was, on any view, before the court. We say that the fact of its existence was something that she was entitled to take into account in assessing whether the assignment and assumption agreement is in some manner inconsistent.
Entitled or obliged?
There were real difficulties in relation to this, but the document was...
Mr. Matthews, I'd be grateful for an answer to the question, please. Entitled or obliged
to take into account the existence...
Well, you said that the fact of the document was something the judge was entitled to take into account, notwithstanding that neither party had adduced it. I asked you, entitled or obliged? Which?
Obliged, if she is forming the view that there was no contemporary evidence which indicated...
Come on, how can you have it both ways? Either it's in evidence or it's not. If it's not in evidence, why is she obliged to take the fact of its existence into account?
Because if there is evidence, which there was before the court, that there was such an agreement, that is something that the court has knowledge of and necessarily has to take into account.
What was the evidence before the court that there was such a document? Was that Mr. Robinson's witness statement or something else?
It was Mr. Robinson's witness statement.
Which you objected.
Well,
and successfully.
My recollection was that we objected to the contents of the witness statement being relied upon as evidence in order to demonstrate the or to argue why the agreement was not.
But something is either evidence or it's not. Once it becomes evidence, there can be argument about what it does or doesn't support. Anyway, I think
we came into this. We came into this from a question from my Lord Justice Nugee as to perfectly legitimately why it was that the assignment and assumption agreement didn't recite the relationship between VBI and the interest of VBI. And all I was seeking to do by way of answer to that was to say, if you look at the what we know to be the position, namely that there is said to be an agreement, the purchase and sale framework agreement of the 9th of July, that perhaps it makes it of less significance that it's not, as it were, a tripartite document that's being dealt with in the assignment and assumption agreement. We've dealt with the yes, and against that background, I was also trying to make the point that the it is still difficult to see what is the supposed narrative in relation to the 2012 sale agreement, if it is being suggested or not that it had not come into existence by the 29th of August 2014. If it's accepted that it must have come into existence by the 29th of August 2014, then it is difficult to see why it can be a relevant matter that the 29th of August 2014 document appeared to be inconsistent with it. It could only potentially be of any force if the case were that the 29th of August 2014 document preceded the creation of the 2012 sale agreement. That's the short point in relation there. It's a forensic point, but it is, with respect, nevertheless a good one. I've already touched on the evidence pointing the other way in relation to the purchase and sale agreement, and what the learned judge said, as we've set out in paragraph 135, is that she gave it little or no weight to the information disclosed by the bank. Little or no weight. It leaves open the possibility that she did indeed give it some weight. That is in effect where I was trying to get to in explaining that you cannot rule out the fact that there was this document. What effect you give to it, if you say in your reasoning there was no contemporary document supporting this, then that is difficult in circumstances where you do know that there was the Deutsche Bank was in possession of a copy of the purchase and sale framework agreement, and as we explain, that is something that obviously we didn't have in our possession. We would have wished to advance it if we had it. and we were unable to do that, and that's what we explain in paragraph 135 of the skeleton argument. There are two items of additional evidence in the additional evidence application, which I'll just flag up, if I may, to demonstrate the existence of the 2012 agreement. The first one is and they're both in the second additional evidence application. The first is an email exchange between Mr. Vik and Mr. Zaroff, his US attorneys, in July of 2014. So that is before the August 2014 assignment and assumption agreement. And we deal with that in that second application at paragraphs 8 to 10 and 24 to 17. It clearly shows, because it refers to it, that the 2012 agreement did indeed predate the assignment and assumption agreement in August 2014. And that is the forensic point that we make. If it is said that the 2014 August document is inconsistent with the 2012 agreement and therefore suggests the 2012 agreement was not genuine, the difficulty with that is that the 2012 agreement was, on any view, in existence at that time.
This is the heavily redacted email, is it?
It is. It is. It's redacted for privilege, save in relation to the obvious reference to the existence of the 2012 sale agreement. And so there's no doubt that it was in existence as at the time when the AAA agreement was entered into. Therefore we say that it somewhat undermines the suggestion that the 2014 AAA being inconsistent with the 2012 agreement therefore somehow demonstrates that the 2012 agreement must be a sham, or, sorry, not bona fides. May I just, I'm going to deal then with the second, just to finish that off, there is no coherent explanation as to why it might have been created between 2012 and the date of the July 2014 agreement, and it would have been very strange had it been created in close proximity to the 2014 AA agreement, let alone if it had been created inconsistently with the assignment and assumption agreement. Subject, of course, to my ladyship's point, if they were acting in a hurry. But that is ultimately always possible, but not, we would suggest, sufficient to hang a man. The second point is the Blanco affirmation from July 2016. Mr. Blanco was the chief executive of the VBI, the right-hand man of Mr. Vik Sr., so Mr. Vik's father's right-hand man, and he, in that affirmation, which we deal with in our second additional evidence application at paragraphs 11 to 13 and 28 to 31, confirms that he entered into this 2012 sale agreement on behalf of VBI, and also counters the unexplained finding of the judge in paragraph 271 of the judgment, that it was, as she said, surprising that there was no correspondence with Blanco. It's in our submission expedient in the interests of justice that these additional bits of evidence, the existence of which had not been previously appreciated by the team acting here, that it should be deployed to avoid the wrongful incarceration of the accused in circumstances where it demonstrates on any view that the sale agreement had come into existence on any view before the assignment and assumption agreement, and therefore, as I say, it's very difficult to see how the inconsistency between those two agreements somehow demonstrates the lack of bona fides in relation to the former.
fact that you didn't know about them doesn't mean that your client didn't.
My lady,
He could very easily have adduced this evidence before Mrs. Justice Moulder. He could have told his legal team it existed, but he didn't, obviously.
my lady, when one is dealing with multi-jurisdictional litigation on quite a large scale, and that is not the sole activity, Mr. Vik obviously has his other primary activities, namely his business interests, to keep all this knowledge and information in your head as to what is out there and what isn't out there. Yes, of course, your ladyship's absolutely right, but these things do happen, and it's, with respect, not exactly surprising that not everything that is recognised as not everything that is actually valuable or useful from other sets of litigation finds its way into every other set of litigation. It's just the way it works, as your ladyship will know.
It looks as if this was a statement in support of a motion to dismiss on jurisdictional grounds. Did that then succeed, and that was an end of it for Mr. Vik Senior and his company in New York?
The motion to dismiss, I will check, but the motion to dismiss did succeed. Yes. I turn then to the irrelevance of the missing documentation, which we deal with in paragraph 137 to 138. There was no evidential basis in our submission on which the judge could place any reliance on the absence of documentation from Mr. Blanco, although it remains a little unclear as to the extent to which she did place reliance on that, although she referred to it in the passage that I've referred to the court from the judgment as surprising that there was no such evidence. In our submission, there was no proper basis for concluding that it was surprising, let alone legally relevant, as to whether there was any correspondence or communication. If in fact the position was that they didn't communicate in writing, well, why should they have done? It was Mr. Vik Senior's trusted lieutenant communicating with Mr. Vik's son. Why should it necessarily have been done in writing? And the fact that it was not done in writing, one might have thought it might be done in writing, but equally it might not be. So why does that lead you to the conclusion, inevitably, that it can't have been a genuine contemporary document, because there must have been contemporary documentation between Mr. Blanco and Mr. Vik?
Well, the oddity, Mr. Matthews, is that if you're creating, however trusted a lieutenant you may be, if what you're actually trying to do is create a legally binding document, it's a bit extraordinary that there isn't one single scrap of paper evidencing some suggestions between them as to what should go into the document, and that it should all be done on the telephone.
It's my fault for not developing this point enough. I'm trying to rush through some of it and I'm failing. This relates to the absence of documentary communication between Mr. Blanco and Mr. Vik instructing the transfer from SHI to Universal in 2014. So I'm sorry, it's my fault.
You moved on from the document, sorry.
Yeah, it's my fault. I hadn't clearly shifted from the one to the other. Right. But yes, so it's that point.
Sorry.
So then turning to the payment of the purchase price under the 2012 sale agreement, this is another, and we say more significant example of the judge forming a conclusion of her own making that the payments under the 2012 sale agreement, which undoubtedly did take place, there were contemporary payments at or about the time when they were supposed to have occurred. The payments were received. What the judge suggested at paragraph 139 to 141 of her judgment was that they might have been loans from the father rather than payments pursuant to the loan agreement. And we address this in our skeleton 139 to 141. And the possibility of the payments being loans was not something that Deutsche Bank had put in the proceedings before Mrs. Justice Moulder, and that's a point, just by cross-reference, we make that point in the application to admit the additional evidence, which I'll come back to in a second, at the unagreed bundle, tab 1, page 8, paragraph 23, where we make that point, and in their response at paragraph 31, in the same bundle at tab 2, page 18, they do not dispute that. The additional evidence is that in September 2013, a list of loans was drawn up in what's referred to as the VBI note. And this is in the additional evidence bundle, the first bundle, and our submissions are in paragraphs 6 to 8 and 18 to 25 in relation to this. And it was a list of the loans that were outstanding between SHI and Mr. Vik's father. And if need were there, we say it isn't, because it wasn't a finding that the judge could properly have made in the total absence of evidence, or of the argument being addressed to her on behalf of Deutsche Bank. But in any event, there is the list of loans which had been created only months later in relation to this, September 2013. And so if these payments, which the learned judge suggested might have been loans rather than payments under the purchase price of the 2012 sale agreement, it would suggest that these were not in fact loans, because the VBI note listed the loans between VBI and SHI from 31st December 2008 to 30th September 2013. And so if the payments had been loans rather than a payment under the 2012 agreement, they would presumably have been on the list, but they were not. Therefore, we say the judge had no proper basis for suggesting and deciding this aspect on the suggestion that these might have been loans, which she does at paragraphs 250 and 251 of the judgment. And obviously, had it been known that it was going to be suggested that these payments were going to be were loans, then that evidence could and would have been adduced at the time. It was, of course, suggested by Deutsche Bank that those payments might have had nothing to do with the 2012 sale agreement, and of course that's consistent with their case, but they hadn't suggested that they might have been loans rather than something else. There is a point is taken which we deal with in the skeleton at paragraphs 142 to 146 as to the irrelevance of the lack of clarity over who drafted the 2012 sale agreement. Again, we say it's difficult to understand on what basis it's suggested that the use of Norwegian law somehow indicates that the agreement is not bona fides. It's not clear whether this is supposed to be endorsing a narrative that the 2012 sale agreement was not concluded in 2012, or whether it was concluded in 2012, but it's somehow said to be a sham or not to have the effect that it purports to. And we also make the point in the skeleton at paragraphs 144 to 145 that the terms of the sale agreement very clearly did contemplate that assets would be transferred over time, a point which the learned judge seems to have rejected, but not on a basis that we can understand from the terms and form of the sale agreement, which we recite at paragraphs 144 to 145. As my Lord Justice Nugee has already indicated, it's perfectly possible too, and we say the sale agreement was an agreement under which you sell the interest now, but on a basis that it's going to be transferred over time. It was recognised that some of those assets were illiquid. In order to achieve a transfer, it wasn't simply possible to say, well, I've sold these, now please immediately transfer them. It was going to take a process of time in order to achieve the transfer, the actual transfer of some of these assets which have been sold. That is directly and expressly contemplated by the sale agreement, as we set out in paragraph 145 of the skeleton argument, and in our submission, the decision of the judge, which we recite in paragraph 144, that the provisions of the sale agreement do not appear to contemplate that the assets will be transferred over time to VBI, which we do not follow. Paragraph 146 of the skeleton, we deal with another point which the learned judge raised, namely that the existence of the trust provisions does not establish when the sale agreement was executed, and that again, we're not aware of anybody ever having contended that they did, and we don't understand how that point has any basis for supporting a conclusion that the sale agreement was not bona fides. The second plank, main plank of the judge's decision, moving on from the internal terms of the 2012 sale agreement and the context of its being concluded, was it said, well, there was belated disclosure of the 2012 sale agreement. This we've covered in our skeleton argument at paragraph 130, subparagraph 2. And again, ties into some of the earlier points that we've been making, the sale agreement was disclosed on the 2nd of April 2014. So if you bear in mind Mr. Zaroff's additional evidence communication in July 2014, that was on any view subsequent to the document having come into existence. If you bear in mind the assignment and assumption agreement in August 2014, that was on any view subsequent to the document having come into existence. So taking all that into consideration, we say it is strange, and picking up perhaps on my Lady Justice Andrews' point, they might have been in a hurry. Given that the 2012 sale agreement was disclosed in April 2014, and the assignment and assumption agreement was not until August 2014, they did have 4 months to produce the assignment assumption agreement, even assuming, at its very worst, that the sale agreement had somehow been created in April 2014. And so we do suggest that this idea that somehow the inconsistency between these documents is redolent of some lack of bona fides, rather than simply being a product of the fact that the sale agreement itself was an agreement between father and son, and not a lot of, well, perhaps not the full panoply of due diligence and legal input had been gone through in relation to that. It doesn't take you any further as to whether the agreement was bona fides or otherwise. It is then said also, the third plank, even later disclosure of the detailed schedule of assets. We've dealt with that in our skeleton argument at paragraph 130, subparagraph 3. The short point in relation to that is that the document was not a contemporary document, and it was known not to be a contemporary document. It was a document subsequently drawn up in order to identify the assets was said to have been transferred. So the very use of the word disclosure in relation to it is, we would respectfully suggest, a misnomer, and no point can be made on the absence of the earlier production of that document. It was disclosed in response to paragraph 6 of Appendix 1 to the Part 71 order itself, and brought into existence for that purpose. And then we refer in paragraph 149 of the skeleton to the fact that the judge again relied heavily upon her credibility arguments, and points are taken by Deutsche Bank on the basis that SHI and Mr Vik did not receive consideration in 2014 when transferring the assets. Well, with respect, you wouldn't expect them to have received consideration because they had sold the assets in 2012 to VBI. You would expect VBI to be receiving consideration in 2014 for the sale to Universal. So that, again, is, we say, a bad argument. The position in relation to the assignment of assets to Universal in 2014 was the working out of those arrangements which had been concluded in 2012 and which SHI was duty-bound to complete, namely the achieving the transfer of assets to VBI or VBI's order, namely Universal, which is what that was all about. Universal, I can take quite shortly. It is and remains somewhat obscure as to the finding, basis of the finding of the Mr Vik's connection with Universal to the criminal standard. The sole basis of the alleged connection is said to be a continuing interest up until December 2015 in Devon Park, which had been transferred to Universal in 2014. It's not clear, just to deal briefly with the concession below, which is said to be a point against me. The point below was that the contempt allegation was the connection was SHI's interest in Devon Park and Mr Vik's father having an interest in Universal. There was a question as to whether the and was conjunctive or disjunctive, and our position was very simply, if Mr Vik's father had a connection with Universal, it is no criticism of Mr Vik, the son, if he says he had no connection in answer to a question as to whether he had any connection to Universal. It is a perfectly proper and accurate answer. The only arguable basis, I therefore said, as to the ground of contempt was the question of whether somehow having an interest in Devon Park meant that Mr Vik had a continued interest, or SHI had a continued interest in, or some sort of interest in Universal. And that was the point on which we engaged, as it were. We say, nevertheless, that it's wrong to conclude that Mr Vik or SHI did have any continuing interest in Devon Park, and we've set out the reasons for that at length in our skeleton at 151, 177, and I don't propose to go back over that at this stage in light of the time. Another of the bases was the existence of the communications with Devon Park, which we cover in our skeleton at 155 to 159. We respectfully submit that it is apparent that an investor who has seen a poor performing investment subsequently learns that it's performed rather better since he's disposed of it. It is not at all surprising if, as Mr Vik says, he was curious to know why that was the case. So that in itself couldn't and shouldn't be held against him as an indication of the fact that he must have had a continued economic interest in it, rather than a, as it were, interest in, well, why is it now doing so well when it doesn't do so well when it was mine? The involvement of Mr Johansson in the communications is not, who we respectfully suggest, surprising. Universal was entitled to receive both the interest and the dividends payable under it. It had been supposedly provided with the investment pursuant to the instructions of VBI given to SHI pursuant to the 2012 sale agreement, and if and to the extent that because of the Devon Park's involvement or otherwise, SHI was unable to complete the transfer of the asset to Universal at the request of VBI, it's not at all surprising that SHI, in the form of Mr. Johansson, would be trying to do something about it to ensure that the transfer could be properly effected and effective. And so we say nothing is to be derived from that. There is a significant foundation placed by the judge on the what is said to have been assumed to be Mr. Vik's knowledge of VBI's affairs, that is Mr. Vik's father's company's affairs. We've dealt with this in our skeleton at 165 to 169. And in a nutshell, we say that there was no evidence that Mr. Vik's father, who had been, he was in his 80s, he'd been a successful businessman, and there is no evidence to suggest that somehow Mr. Vik Sr. needed or had the involvement of Mr. Vik Jr. in managing his affairs for him in some way, so that Mr. Vik Jr. must have known the details of what Mr. Vik Sr. was doing in relation to this asset in selling it to Universal in 2014. There's simply no basis for that. And what effectively the learned judge did was to say, well, if Mr. Vik was so curious as to find out how Devon Park did by asking Devon Park why it was performing so well after he divested himself of his interest, then he equally would have been curious to know how and why and on what terms his father was selling Devon Park to Universal. Well, that is, with respect, simply doesn't work. The fact that an investor who has disposed of his interest is interested to know why the investment has done better since he sold it on, and challenges the investment managers, in effect, in relation to that, to say why, what's changed here, why is it doing well when it didn't do well before, it is a totally different matter from saying later on, well, you therefore must also have been interested to know the terms and details on which Mr. Vik's, on which your father was disposing of it. But anyway, the judge had rejected Mr. Vik's case that it was curiosity that had led him to make that inquiry. And so to count against him that argument is very much a question of eating the cake and having it. If Mr. Vik had known of the terms on which VBI had disposed of the interest Universal, it was never suggested as to why it might have been in his interests to keep that quiet. So that again is something that doesn't make sense on the evidence. We dealt with the position in relation to the SHI's, Mr. Vik's involvement with SHI in paragraphs 178 to 183. We simply, I'm afraid, do not follow the basis upon which it is said that Mr. Vik had a continued involvement in the affairs of SHI through the interest in Devon Park, and there's no other undisclosed basis of continued involvement. So we do not see what the point is. It simply begs the question of whether Devon Park was SHI or Vik's interest. If you accept that Devon Park was not SHI's interest, then Mr. Vik is right in saying he has no continued interest in SHI's affairs. If, contrarily, Mr. Vik is wrong about that, and there was a continued involvement of SHI in Devon Park, then, of course, you don't need this separate head. But there can't be an independent basis upon which there was an involvement by Mr. Vik in SHI's affairs, unless it was the Devon Park interest, which is a separate point which I've already dealt with. There's no separate basis of analysis in relation to that. IFA shares and Universal raises only one short point, which I'm going to go through quickly, if I may. The only point in relation to IFA, the only independent point, is the existence of documents relating to voting rights. We deal with this at 190 to 193. And the short point in relation to this is that in 2008, you have the securities agreement by which SHI transferred the shares in IFA to a company called Vik Beteiligung. Slightly confusingly, it is not the same company as VBI, obviously. So Vik Beteiligung borrowed the securities. Vik Beteiligung was jointly owned by Mr. Vik and another shareholder. And those shares were transferred by way of the securities agreement in 2008. In 2012, we say, the interest in the IFA shares themselves was stated in the schedule of assets, but if one correctly analyses the securities agreement, it's probably a right to have transferred back an equivalent number of shares, was sold to VBI. So that's 2012. You've got the sale to VBI of the IFA shares or the right to have them transferred. 2013, Vik Beteiligung went into liquidation, and the shares were then transferred from Vik Beteiligung to Mr. Vik. And as the judgment recites at paragraph 352, Mr. Vik's case was that he'd settled a dispute with IFA on terms that he'd have a seat on the board and hold shares. So he needed to hold the shares, and he says it was agreed with VBI, who would otherwise have been entitled to the transfer of the shares, that Mr. Vik would hold them in that context. The short point is that Mr. Vik did hold the shares, albeit clearly under an obligation to transfer them ultimately to or to VBI's order, whether directly or indirectly, it matters not, because SHI had promised to transfer the shares to VBI under this 2012 sale agreement. And there was no inconsistency between the way Mr. Vik held the shares and the fact that that VBI was ultimately entitled to them pursuant to the 2012 sale agreement. The regulatory notifications in relation to the voting rights, we respectfully say bear that out. We deal with it at paragraph 194 to 197. They deal only with the voting rights and don't tell you about the beneficial or legal ownership of the shares. As explained in July 2013, the shares, together with the voting rights, were held in the name of Mr. Vik pursuant to the settlement agreement with IFA and with the sanction of VBI, or the permission of VBI, on whose behalf SHI had previously been holding the shares or the right to the return of the shares. The electronic documents, we deal with this in our skeleton argument at 201 to 212. We draw particular attention to the search that had been carried out of Mr. Vik's emails by Breacher, which is referred to in our skeleton at paragraph 210. Our basic position in relation to the electronic documents, there is a clear deletion policy which had been adopted by Mr. Vik of long standing, long predating the dispute with Deutsche Bank, which, for the reasons and in the manner that we explain at 202 to 212, ceased, resumed, and ceased again. And it is not surprising in those circumstances that further electronic documents, there had already been disclosure of some electronic documents in the context of the trial itself, but disclosure of further documents did not identify any relevant electronic documents. And we note again that heavy reliance is put at paragraph 415 to 417 in this context on the Carlisle transfer deeds point, which we say she should not have relied upon. The documents held by third parties, we deal with at 215 to 218. The short point in relation to that is there was no evidence that there were, or that Mr Vik thought that there were, and therefore deliberately withheld other documents held by the banks which would have been responsive. No other documents have ever been produced by the banks, even when they were subpoenaed. Merrill Lynch produced bank statements, and Mr Vik had already produced lots of bank statements, and JP Morgan produced some information but no documents in response to the subpoena. So it's not clear what evidence there is that there were documents that the banks held which should have been provided. Mr. Johansson is dealt with at paragraphs 219 to 220, and the short point is that Mr. Vik's evidence was that he did not know exactly whether Mr. Johansson had other documents which were responsive, and Mr. Johansson was obliged to provide, or what process exactly Mr. Johansson went through, that he'd done his best to comply with the extensive requests in the limited time. And to preserve myself some time in reply, the appeal against sentence, we've dealt with that at paragraphs 223 to 231 of the skeleton argument. We say that the learned judge was in error in imposing a sentence at the level that she did, even in the light of the findings that she made, but that if we are right in relation to some of the points, then obviously that impacts potentially upon the level of sentence, and we say it should be reduced. If we are right about all our points, then there shouldn't be a sentence at all, of course. So, unless there's anything I can assist further with at this stage.
No, thank you very much.
Thank you.
Yes, Mr. Vik.
My Lord, by this appeal, as you've heard, Mr Vik is simply seeking to relitigate the whole of an 11-day hearing. That includes 10 days for the original hearing and 1 day for the sentencing hearing. And what we haven't heard through all the many submissions you've had for a day and a half is really an engagement with the actual hurdle that Mr Vik has to overcome. And the threshold is not to have a rehearing, but to review the judge's decision. And because all of the complaints, we say, are entirely complaints of findings of fact and credibility, there is no scope for this appeal. And it was notable that despite the fact that we have flagged this point in our original skeleton and in the subsequent skeletons, including the one served on permission, we really didn't get any engagement. In passing, Mr Matthews suggested, I think this was at day 1, page 139 of the transcript, that the Court of Appeal's recent decisions on appellate interference did state the principles properly, but he then skated over what those were, and he also tried to suggest that Volpe was narrowly expressed, and that Walter Lilly was the more extensive analysis. So can I just deal briefly with that? The relevant cases are Walter Lilly, Curican and Volpe. Those are at authorities 45, 46 and 51. As my Lady Justice Andrews will know, there's also the Privy Council decision in Kwok and Yeo. And the reality here is that your Lordship and Ladyship need to be persuaded that the judge's findings were so unreasonable that no reasonable judge could have reached them. So, although Mr Matthews has tried to say, for example, I don't know how the finding could have been made about universal, he said, I think last, that is not the job of this court. The judge heard the evidence, and I'll come on to that, and it's not the job of this court to try and pick through the different findings and work out whether this court would have reached the same decision. You start from a much higher threshold. And the statement in Volpe is a good statement, and if I can just show you that, it's at Authorities tab 51, that's volume 3 of the Authorities bundle. And it's at paragraph 2. And I'm sure that the court is very familiar with this, so I'll just allow you to remind yourself of the statement made by Lord Justice Lewison, and he was summarising in detail and at length well-settled principles of general application.
Sorry, which bundle of the authorities did you say?
Bundle 3.
We've got 6 bundles, and in mine it's bundle 6.
It must be bundle 6, it's tab 51, I'm sorry.
That's my confusion. Thank you.
I've been reminded that my Lord Justice Males was in the case, so the judges in the case will be very familiar.
Doesn't follow at all.
And paragraph 2 is the relevant paragraph.
Yes, I mean, plainly wrong, rationally insupportable, no reasonable judge. These are all different ways of expressing much the same concept, aren't they?
That's right. And if you look at paragraphs 65 to 66, there's the well-known now expression of island hopping,
Yeah.
Which is precisely what we've heard for the last day and a half.
There's just one useful expansion that I found in Lord Reed's speech in Henderson and Foxworth, which refers to the situation where the judge makes a finding which is simply just not available on the evidence. In other words, there's no evidence to support it at all, or misunderstands the evidence. I mean, that comes under the umbrella plainly wrong, but it might be said by Mr Matthews that we're in that sort of territory here.
Well, the only point that he has identified that would fall into that sort of territory is the new case that has been attempted to be introduced this morning. You've seen my email on that, and we say that shouldn't even be permitted because you can see from the introduction the appellant's factual case. It can't be introduced on day 2 of an appeal, and the reason why the judge, he says, has misunderstood the evidence is because of an argument he never made. So I would submit respectfully it can't come into what Lord Reed had in mind, and I'll take the direction from the court as to how you wish to deal with that in a moment perhaps. But separate to that error, or identified error, he says, there is no other error that falls into that category, because every other error he alleges, and I'll go through them, is an error as to the judge's conclusion and what, for example, not giving Mr Vik the benefit of the doubt, as opposed to there being no evidence on the point.
Well, there is perhaps a distinction between his overall 3 points, wrong to take account of previous findings, wrong to have regard to abandoned allegations and unrealistic standard, which are, if correct, points of principle.
Yes.
And then the more specific points, which form the second half of
That's right.
Matthew's submissions, where you make the point that this is relitigating facts. But as to the
new case, at the moment, and subject to argument, it seems to me that there is quite a lot of detail in the document that was produced this morning, and it may be that you have a point about some of that, but Mr. Matthews' fundamental point was that there was no case advanced below and no evidence to support the case that Mr. Vik signed the agreement twice, and that the judge, essentially that was the judge's own point, on which she placed quite a lot of weight in her assessment of his general credibility. And I think I would be interested to know, whatever your objections may be to the wider narrative case advanced, what your position is about that. And if right, what and suppose Mr. Matthews were right about that, but wrong about everything else. And I'm not in any way suggesting that's the position, but just suppose that, then what would be the consequence of that for this appeal? Those are points which,
Indeed.
at some point, it would be interesting to hear your submissions.
Well, I'm going to come on to them, but briefly, the answer is, point number one, it's still a new case. So just because it's honed down into the way your lordship has articulated it at its nub, it doesn't actually go in automatically. It's still an abusive process, and we've cited the authority for that. And Mr. Matthews should have to engage with that point rather than, with respect, sneaking it in yesterday in submissions, not saying it was a new point, and then developing it differently in writing today. And it does have to be looked at quite carefully, and the reason it's not just a forensic point, if this was so obvious, this material was before Mr. Vik from, I think, 2015 or so, and he had full notice of the case that was being advanced. He was then cross-examined on it. He wasn't re-examined on it, and nothing was put in writing, and then nothing was put in this appeal.
He says, and we haven't been shown anything which contradicts it, that he didn't have notice of a case that he signed the document twice, and that was not something which was put to him in cross-examination. I mean, if that's wrong, and
no,
there is something...
that is correct. I did not put that. I obviously put to him that the page was identical.
Yes.
And he could have been re-examined on that, and he wasn't. He was not re-examined on anything to do with this or at all. But more significantly, none of that explains why in the appeal grounds and skeleton this point wasn't taken. It's not explained why a supplemental skeleton, if it was realised, wasn't put in with permission sought before the appeal, in circumstances where, as I've said, a skeleton argument was actually put in on Monday evening on something else. And it must have been known by then this point was being run, as it was run on Tuesday morning. So none of that's been explained, and none of it's been explained as to why the case has now developed even further on day two of the appeal. So that's the abuse point, and you've heard my submissions on that. And I can show you the relevant authority when we come to it. The second point is, does it make any difference whether he's right or wrong? Which I'll address you on, and the short point is no, because a cherry-picked example of one error, and we don't accept it was, but one error, wouldn't undermine the whole judgment and the analysis, and one can see that in many different ways. Just on the general credibility point, there is no justification for saying that finding and that finding alone was all of the general credibility points the judge relied upon, and one can see that from the face of her judgment. There were many. Even if it were the case that were significant, what the judge then did, as I'll show you, is go through each finding and find specifically on the evidence before her why Mr. Vik was lying. So the premise of Mr. Matthews' argument that this somehow underpinned everything is just not sustainable. And in any case, it wouldn't undermine the whole judgment, even if it had had some significance, which we don't think it The third point is then the detail of the case. And on that, I don't propose to address you today because we are going to need to look at it. The short point is, and your lordship should have this in mind, in your ladyship, that Mr Vik's case, on some level, whatever it is that he was dishonest. Because at one stage, I don't know if your lordship has picked up on this, it was suggested that Mr Vik wasn't lying to the court, but had lied to the tax authorities. I'll show you that. This case now still doesn't engage with, from what we can see, why that it was ever backdated and why he only disclosed that version. So fundamentally, and that's the mischief of this, it's seeking to recast things without actually ever answering the question. And of course, those questions couldn't be put to Mr Vik. So, my lord, we'll engage with the detail of it, but we say it's misconceived anyway because there is actually an explanation for the judge's finding, but I need to look at the detail of what's been said to cover all of it. But in any case, we say, fundamentally, this has become, interestingly, and it was, the main plank of the appeal. It took up it took 3 hours in the end. And it's a new point, and it's the main plank, and we say it's misconceived. And my Lord Justice Mayles is right that the arguments fall into two buckets. One are these general points, and the other are the specifics. In relation to my Lady Justice Andrews' point, the only error that would be in that category is the new points. So the others are just reviewing findings of fact. The general points, we say, come nowhere near to A, undermining the judgment even if they were right, because of the specific review of the facts. And secondly, they come nowhere near to undermining them in any event, given the legal test, which notably my learned friend never really engaged with. So can I show you why none of the findings that Mr Vik can be impugned, seeks to impugn, can be impugned? And the judge's starting point is very important.
Just before you do that, and before we move off Volpe and the general principles, is there any difference in an appeal on fact where the facts have to be proved to a criminal standard beyond reasonable doubt from a normal civil case?
No, and my learned Jenny will find you the authority on that. There is not. And there is actually an authority effective the reference, my lord.
Because in criminal convictions, the test is not the same. The test is whether the conviction is unsafe. If the court feels a lurking doubt, then the conviction is overturned. But that doesn't apply.
We say that doesn't. The case I've got in mind, I think, is Navigator and Lady Justice Carr.
Yeah.
But I think there may be a further statement on it, and Miss MacDonald will check, that these are quasi-criminal proceedings.
I understand that.
And it's not right that you look at unsafe, you look at it to the civil standard, but having had the findings proved to a criminal standard.
Yes.
And that's what the Navigator case says, admitting a different context. But I think there may be more than that, so we'll get you the reference.
Thank you.
So, my lord, the judge's starting point was that she was required to make an independent assessment of the evidence before her, and that is what she did. And I have 6 points on that. First of all, it was very clear from the very first day of trial that the judge was not approaching the case on the basis that she was bound by previous findings. You can see that from the transcript, and I'll give you the reference to that. It's the Supplemental Bundle 1, Tab 2, page 79, at page 126. I don't need you to turn it up, but if you look at that, you'll see that I came in for quite a hard time because I was seeking to introduce, at that stage, by way of context, the findings of Mr Justice Cook, the trial judge who'd heard the trial for 14 weeks and heard Mr Vik give a 2 weeks' worth of evidence. And Mrs Justice Moulder was not interested and was very clear that her job was to look at the evidence before her. So that criticism really is not a warranted one, and one can see that from the face of the judgment. I don't know if my Lord Justice Mayles wants the line reference. It's line 13 to line 22, page 126.
Thank you.
The second of my 6 points is that the judge had, and I think this was a point made by Lord Justice Nugee, a vast amount of documentary evidence before her, including a 170-page affidavit from Mr Hart in support of the application. She had detailed, lengthy written opening and closing submissions from both parties. The case took 10 days, which is unusual for a contempt case. So she heard all of that and had all of the material shown to her. Third, and again, quite unusually, she had 4 days of evidence from Mr Vik himself. And she had a direct opportunity to evaluate him as a witness and assess his credibility. And she did so by herself. She did not have regard to Mr Justice Cook on his credibility. She made her own assessment. Of course, other judges have made that assessment, but Mrs Justice Moulder did it herself. Fourth, in her judgment, she referred to what she regarded as the key points. The best examples of that being at paragraphs 202, for example, Beatrice and the Trust, and other examples were 247 to 248. Now, she says in her judgment that she will have taken into account other documents and so on, and her written judgments on its face state that she presents the highlights essentially from the evidential run. Now, that is one of the reasons why, like the Volpe case, this appeal is a thoroughly inappropriate venue for relitigating the trial. And one of the things I'm going to come on to show you, regrettably, is that a number of points that were made about what happened below are just not correct. Just not correct. It was said, by way of example, that a case of similarity was run on the Norwegian law point. No, it wasn't. It's never run. And I'll show you the closing submissions on that. And it's one of the reasons why trying to delve back into precisely what evidence was seen is incredibly dangerous, particularly if I can show you, and I'll show you at least 10 errors in what you've been told, that you're not actually being told exactly what the judge had before her. There was an elision, as you heard, about the Norwegian law evidence. The Klug memo was not before the judge. So it's not the right venue. Fifth, the judge correctly directed herself as to the law, and you can see that very clearly in her judgment. And sixth, contrary to what my learned friend suggested yesterday, the judge did actually give Mr Vik the benefit of the doubt where appropriate. She was cautious about that. Best examples are paragraphs 53, 389 and 401 of her judgment. So those are the 6 high-level points. Can I then turn to credibility? And our written submissions on credibility are set out in our skeleton at paragraphs 50 to 86. And what you can see is that the judge evaluated Mr Vik's credibility in detail, paragraphs 49 to 107, and concluded that his evidence should be treated with considerable caution. And that conclusion was reached with care because, as I said, she had all the relevant material before her and 4 days in which to examine him. And just to put this in context, my lord, one of the criticisms made of the Part 71 hearing was that Mr Vik didn't understand the questions. And the mainstay, as I'll come on to show you in his affidavit, for example, on Beatrice or Universal, was that he did not understand. And so one of the things that the bank was very careful to ensure, and indeed the judge was as well, was that every time Mr Vik was cross-examined on a topic, he was given repeated opportunities to say if he didn't understand or to answer the question. And I'll come on to show you in the context of Beatrice that at the very end of the cross-examination, a question was put to him, I think, 4 times, the last 2 times at the judge's invitation, because he was not answering it. And the judge didn't want any suggestion that he'd not had the opportunity to answer the question.
You're referring there to the committal cross-examination.
Committal.
Yes.
So, and it's the passage I think your Lord Justice made.
Yes, I think we have seen that.
It's page 56. You mentioned it yesterday, because his case on Beatrice, up until the hearing, was I didn't understand the questions, and if I'd understood, I would have given you different detail because I knew something about Beatrice, but not precisely what you were asking. That was his evidence. In cross-examination, his evidence was, I knew nothing about Beatrice. I was told to distance myself, I had nothing. So when I put to him at the very end, well, if your case is you knew nothing, why have you come to court saying you didn't understand the questions? Because your case is you knew nothing. And he, obviously, bright man, couldn't answer that, so just chose not to. And the question was put to him 4 times. So Mrs. Justice Moulder had repeated examples of his credibility and found specifically and generally. And it's also important to just stand back and remember that the Part 71 hearing came about because Mr. Vik's creature company did not pay the judgment debt found by Mr. Justice Cook after a 14-week trial in 2013. And Mr. Justice Cook found, and it's a binding finding, it was not appealed, lots was appealed, this was not appealed, that Mr. Vik asset stripped SHI so that it could not pay the judgment, and then the Court of Appeal found that at a moment's notice Mr. Vik could have returned those assets to SHI, but had
You
chosen
say
not
it's
to.
binding finding. Is it binding on Mr. Vik?
Yes, it is, because, I'll tell you why, my lord, we'll come on to this. Your lordship asked about, this is another of the things that you were not given an accurate summary about, so may I just show you that now? I don't think your lordship appreciated that the non-party cost order judgment of Mr. Justice Cook is the one that Mrs. Justice Moulder had regard to about the sale agreement. It was not the trial judgment. And that judgment was against Mr. Vik personally as well as SHI, but for cost purposes.
He was joined as a party
because
for
he was
cost
joined
purposes.
as a party. Now, the reason I say the previous one was binding on Mr. Vik was through that cost point, and that's how I'm saying it was binding. I appreciate he was not a party to the SHI original trial, although he gave evidence as the principal witness. And the reason it's binding to an extent is that it was never challenged, and that's the only finding that's still there.
I'm sorry, I'm being a bit slow. I understand the point, but if it's not appealed, a decision is binding as between those who are parties to an action. But the trial, the 14-week trial, Mr. Vik was not a party.
No,
So
he was
it's
the
it's
principal
binding.
witness.
Yes, but the fact you're a witness and the fact it's your company which is a defendant does not make the findings of that binding on you. There's no issue as to because you're not a party. So is your submission that the fact that subsequently to the trial he was made a party for costs purposes somehow makes the findings at trial binding on him?
Well, my lord, yes, in the sense that if he tried to relitigate those now, it would be an abusive process.
Is that right? He couldn't have
No.
appealed them.
Well, he was found to be the real party for cost purposes, and he didn't direct SHI to appeal those findings, notwithstanding him being found to be the person in control and directing the litigation.
This seems to me quite a far-reaching and quite, if I may say so, novel submission, unless there's authority of which I'm unaware. I start from what I think is a fairly simple position, which is that decisions are binding on those who are parties or those who are privies, and you're not privy to an action just because a company which you are the sole owner and director of is a party. And I understand entirely that there is a costs jurisdiction to make costs against people who aren't parties on the basis that they're the ones who really stand to benefit and who have really directed the conduct of the defence and so on. But I'm not aware that that makes you, for estoppel purposes, a retrospective party to the action.
Oh, my lord, can I cut through this?
Yes.
I don't need to argue this point.
Right.
I'm very
Okay.
confident that if it came and it would be found to be an abuse if Mr. Vik now tried to relitigate it on the basis he wasn't a party. But I don't need that point. The point I'm making is that SHI, I don't think this is disputed, was obviously a judgment debtor, and Mr. Vik, as a former officer, was held to be the person responsible for having assets stripped, SHI, and he was ordered by Mr. Justice Tier to give evidence as to where those assets were. And that's the context. And it's important to remember that, because I appreciate the court gives leeway to somebody who's been committed to prison. But it is important to remember that the reason Mr Vik was there, both at the Part 71 and at the committal hearing, was because his answers were such that he was not telling truthfully where those assets were when he knew. And it's important to have that context. And can I just deal with the cost point, because I'm taking it out of order, but I think it is important just to show you this, because you were taken at some pace, I think, at times through submissions. But the position is, you've seen that Mr Justice Cook gave the trial judgment, and I accept against SHI. Mr Vik, as the principal and only witness for SHI, gave, I think, 2 weeks of evidence. And the judge made findings about the asset transfers in that context. There was then an appeal to the Court of Appeal about conditions on the appeal, and that is at tab 2 of the authorities bundle. And can I just show you, before we go to that, the judgment before of Mr Justice Cook that I've been mentioning, which is at tab 3. This is the non-party cost judgments. And you see at paragraph 1, the judge saying that he gave judgments against SHI. And paragraph 3, that he gave permission for Mr Vik to be joined for cost purposes. Now, this was an application on the non-party costs, and the judge covered all the law and found that Mr Vik was the real party. And if one picks it up at paragraph 66, there you'll see the judge recording that he found that Mr Vik transferred assets out of SHI with a view to depleting those assets. He goes on to say, at paragraph 1461, I concluded that all the funds which he had transferred were still available to SHI because Mr Vik could at a moment's notice have procured the retransfer, and that passage was also a finding within and cited within one of the Court of Appeal judgments subsequently. And what the judge then goes on to find is that Mr Vik was in control of the proceedings. That's in paragraph 69. And that he was responsible for causing SHI to bring dishonest claims. That's at paragraph 72. Now, one of the points made by Mr Vik, you see at paragraph 82 of the judgment, which he tried to argue that he stood not to benefit from the litigation because of the credit line or loan line between Beatrice and VBI. And new evidence was produced to Mr Justice Cook time after the trial. And you see on page 743 within paragraph 81 the reference to the fact that SHI's financial position had been directly an issue and there was no room for the new evidence. And then if one goes over to page 87, here we see suddenly the sale agreement is adduced. And the sale agreement was produced in 2014 in this context, redacted, and you see that at the bottom of paragraph 87, that was Mr. Johansson confirmed that the purchaser was not Mr. Vik nor a company controlled by Mr. Vik. We know who it was now. It's his father's company, but it was redacted. And
was this the first mention of
Yeah.
the 2012 agreement?
exactly, this is how it came to be produced. In order to resist the idea that there was a benefit and that also that SHI had funds.
So the one thing that we can be absolutely certain of then is that that agreement or alleged agreement, or the document that purported to be that agreement, was around in physical existence in or around June 2014.
That's right.
Yes.
That's right. But
I
we haven't.
think we were told it was disclosed in April.
April, yeah.
Mr Matthews had a point this morning that it was clearly in existence before the AAA.
But the point is that it wasn't produced in the trial, and these were the circumstances in which it came to light. And I'm just coming on to, if you see then, paragraph 88 is where the trust, the Norwegian trust point comes out. Now, there was evidence adduced by the bank as to Norwegian law. So when you were told Mr. Justice Cook had no evidence, that's not correct. And you can actually see that from the Klug memo that has been now adduced. And he did have evidence, and Mr. Vik didn't contest that evidence, didn't adduce his own evidence saying anything different. And it was on that basis that the judge, Mr. Justice Cook, found that under the law of Norwegian law, there was no concept of a trust. And it's this that Mrs. Justice Moulder was referring to, not the trial judgment as you were told this morning. I'm sorry, I'm being reminded that Mr. Vik, in fact, adduced the Klug memo before Mr. Justice Cook on this hearing. So the one that he's now trying to put in was produced before Mr. Justice Cook. And, of course, we'll come on to that, but the Klug memo actually supports the fact that there's no trust concept. So this is how it all came out. And then if you go over the page to page 97, paragraph 97, you see he then deals with the new evidence as to the existence of loans between Beatrice and SHI. Again, this is the first time the relevant alleged documents are produced, notwithstanding this had all been an issue at the trial. And the judge, first of all, says there's no justification for this having only been adduced now, but secondly, in any case, makes the point that it doesn't help him. So, the other point that you should be aware of, and I'm sure you have picked up from the judgments, just while we're on the context of this, I'm going to come back to it is that when Mr. Matthews said to you several times that the bank's case wasn't clear on certain things, well, Mr. Vik made an application before Mrs. Justice Cockrell challenging the particularity and clarity of the contempt application. And that judgment is in the bundle at tab 6. And Mrs. Justice Cockrell dismissed that application and held that the contempt application in all its form as served was clear, and the attempt to strike it out was rejected. So it's not right to say that Mr. Vik didn't understand, because he had a good shot at it, saying that in front of Mrs. Justice Cockrell, and permission to appeal that was refused.
I think the specific point, or at least a specific point, where Mr. Matthews was saying your case was not clear was in relation to the 2012 sale agreement, and in particular whether your case was that was a document which did not exist in 2012 but came into existence later, as we now understand, sometime before April 2014, or whether your case was that
although it may have been in existence in 2012, it was a sham which was never intended to take effect, or he said some other possibility. Can you clarify that?
I'm going to, my lord, but what I'm going to do is find you, because we set this out in writing, because Mr Vik, my recollection is, tried to argue that, and we set it out in writing. And I will get you the reference. So when Mr Matthews says that Mr Vik didn't know, I don't think that's right, because I think we've told him.
All right, well, that
So
would be
I'll
helpful.
check. I will check that. I know what the answer is, but I want to find.
You'll keep us in tenterhooks for a bit longer.
So, my lord, what we would say is Mrs Justice Moulder was aware of that contest, but expressed a lack of interest in it. And what she did was look at Mr Vik give evidence, and she did that sensibly and diligently, because you can see from the length of her judgment that she took it very seriously and went through every alleged error individually. Now,
Is it right, I think it is, that the only occasion when Mr Vik had given evidence before the Part 71 hearing was at the trial?
that's right. So this was his third time
Yes.
giving evidence in this jurisdiction. And he, as I said, my recollection is it was around 2 weeks at the trial. He then had the day of the Part 71 hearing, and he then had 4 days before Mrs Justice Moulder.
And were there witness statements or affidavits post the trial but before the Part 71 hearing?
Yes.
There were, so right. But so far as all evidence is concerned, any findings about credibility must be based on the trial, although I suppose judges might have said something in an affidavit was not credible, if that was the case.
Well, the Court of Appeal have made a number of statements about Mr Vik. I can take you through them, in which they commented on him, but obviously they didn't see him.
Yeah, yes.
So, but there have been, I think, at least 3 judgments of the Court of Appeal to date, rejecting. I know Mr Matthews presented Mr Vik as having had some success. He had success on challenging a method of a point on service out, which ultimately didn't help him. Other than that, he has had all of his applications, including many attempts to go to the Supreme Court, rejected.
Right.
So, now, Mr Vik identifies 3 categories of alleged errors in the judge's approach. First, the reliance on prior findings of Mr Justice Cook on credibility. Second, the judge's findings allegedly on abandoned allegations of contempt. And third, a sort of mixture of other alleged errors, which my learned friend recharacterised yesterday orally as the judge, in effect, adopting an unrealistic high standard in assessing the evidence given by Mr Vik. And that was at the transcript, page 24, lines 3 to 6. Now, taking the
I think that phrase is in his skeleton as well, actually.
Right. Taking the, I think the skeleton goes to a number, and I'll go through them. But Mr Vik suggests that the judge was wrong to attach any weight to Mr Justice Cook's adverse findings. That's in his skeleton at paragraph 33. We have struggled with this because it was conceded below and yesterday that the trial judgments of Mr Justice Cook and judgments were admissible. You can see the concession in Mr Vik's committal skeleton before Mrs Justice Moulder at paragraph 78 and paragraph 106. Now, no qualifications or caveats were put on admissibility, so the case today that somehow there's a caveat around the judge's findings on Norwegian law, we didn't follow, and if we would like a reference to that, I know there was a case run on Norwegian law, and I can show you what it was, and I will, from the closing submissions, but there was no caveat on the admissibility in the context of Norwegian law. And when Mr Matthews suggested yesterday at page 43 of the transcript that certain findings were only admissible for certain purposes, no argument like that was made below, and we say it's not open for different argument to be advanced on appeal. The judge was not the beneficiary of that argument. There was an argument on issue estoppel, and that fell by the wayside. We didn't pursue an issue estoppel, and in the end, Mr Matthews didn't over the Connecticut judgment either, although I think he went at it with a bit more vigour than I did on the other point. So issue estoppel fell by the wayside, and admissibility was common ground. And we say there wouldn't be any principled basis for limiting the use of prior findings in any event. And Mr Matthews didn't refer you to any authority to support the submission that there should have been a limitation. In any case, we say it's all irrelevant because the judge formed her own independent assessment of Mr Vik's credibility and said in terms that she wasn't placing reliance on Mr Justice Cook's findings to reach a decision on the contempt application. And you see that at paragraph 43 of her judgment. Now, we accept that she took into account, which we say she was entitled to do, Mr Justice Cook's findings, but she made it clear that the only purpose for doing so was in support of conclusions she had independently reached herself. And you see that again in the judgment at paragraph 43 and 53. And the very passages of the judgment Mr Vik relies upon, which are 327 to 329, in fact demonstrate that the judge relied on Mr Justice Cook's findings only to reinforce findings that the court has reached independently of Mr Vik's credibility. That's in paragraph 327. And I think it was the point that my Lord Justice Nugee made yesterday at the transcript, page 47. That's the only example of reliance on Mr Justice Cook's findings that Mr Matthews has pointed to. And it's the only one in the judgment. So, in fact, she only referred to Mr Justice Cook's findings in support of one specific point, and it was one where she said she'd independently reached her own view.
You said, I think, that there might be others, but in the event we were not shown any.
Not shown. And we can double check that, but that's certainly what we have gone through and found. I'll be corrected if I'm wrong. And what we say is the judge independently reached findings that were set out over quite a swathe of paragraphs. It was paragraphs 249 to 287. And no reference in that section is made to Mr Justice Cook's findings. And my Lady Justice Andrews said yesterday the only use of the findings might have been as a reality check, and there is nothing wrong with that. I mean, if anything, it's very sensible for a judge on a very serious application. First of all, she told me, counsel for the bank, that she was not interested in the context before she considered everything independently. She did consider everything independently. Mr Vik was given a lot of leeway, including when his connections and things went down, and the bank objected to him ever being permitted to give evidence remotely, yet he was given that opportunity. And every opportunity was given to him to make sure that it was fair. And the judge should be commended rather than criticised for then stepping back and saying, I've reached this finding, and actually I'm reinforced. So,
Did you object? Your letter from which we were given overnight said that you would give reasonable consideration to any request to give evidence by way of video.
We did. But
you then rejected after that.
Well, we became quite concerned about what law would apply because he was based in France, I think, and Mr Vik didn't make in due time, we said, the relevant applications to give evidence remotely. And we became concerned that he was not going to go through the relevant procedural points. And so we said it was better for him to give evidence. We were then, in fact, for some time we didn't know whether he would give evidence or not until actually I think the day he did. And then he gave evidence, but his setup was very poor. And that caused quite a lot of delay and disruption, but it was accommodated. So that was the chronology. My Lord, can I finish this point quickly and then I won't go much beyond. But what I was going to say was that the judge's approach was also in line with existing authority in relation to committal applications. And in the skeleton served by my learned friend, Mr. Matthews suggested that the decisions in Al-Giberi and Helen, that's Bailey and Bailey, were either poor judgments or shouldn't be followed. That was in his skeleton in paragraphs 48 to 53. Yesterday, at the transcript, page 55, lines 22 to 24, he said he was not saying these decisions were wrong. So I think we can proceed on the basis now that it's common ground that those two decisions are appropriate, and indeed, in any event, Bailey and Bailey has been commended in WA decision of the Court of Appeal at paragraph 39 recently. Now, both of those cases make it plain that the judge hearing the committal application had regard to prior findings of dishonesty. And we can see that both in the Al-Giberi case, which was Mr. Justice Spencer, and in Bailey and Bailey, which is Mr. Justice Peel. I'm conscious of the time, my lord. I'm happy to deal with these cases now in 5 minutes, or to do it after the break.
All right, well, let's do it after the break.
Wheelchairs?